In this video, I'm going to speak to you about spousal maintenance in particular, but this time post-divorce. So in the previous video, I spoke about interim maintenance pending the divorce. This time I'm going to speak about maintenance for a spouse after a divorce. Now, maintenance after a divorce is not an automatic right. This is something that you actually have to prove, and there are various issues that are taken into consideration when a court decides whether or not to grant an order for maintenance post-divorce, whether that is for a lifetime or for a specific period of time. Now, there are sort of two types of maintenance. It's either lifetime maintenance or what we call rehabilitative maintenance, which is for a period of time, which is anything from, say, 6 months to a year, up to 5 or more years, depending on the specific circumstances of each matter. Now, lifetime maintenance is quite rare, and it is usually in circumstances where the spouse requiring maintenance is usually unemployed and has not been employed for a considerable period of time. This happens, for example, with older clients who are perhaps in their late 60s or early 70s, where, for example, the wife was a stay-at-home mom and never worked and always just went, traveling with her spouse when they went away on business or when they went away together, and lived a life of relative luxury, and now is unable to enter the job market because of his or her age. Usually it's the wife. Then there are circumstances where one of the spouses is unable to earn an income because of a health issue. So, for example, a spouse may have had a terminal illness and is not able to work, or they are a survivor of, for example, cancer, and they've had some kind of ongoing issue that they are unable to work. Perhaps they had a brain injury. That means that they're unable to support themselves. These are the sort of things that might entitle a spouse to lifetime maintenance. But I do want to point out that lifetime maintenance can be incredibly problematic. And it often happens that the spouse who is directed to pay maintenance pays for a period of time and then at some point decides that they no longer want to pay. Or that spouse now decides to retire, reaches the age of 70 or whatever the case may be, decides they want to retire, and they're no longer earning the income they used to earn, and now paying the maintenance they were ordered to pay becomes problematic. So these sort of things always need to be borne in mind if you are going to include in your summons a claim for lifetime maintenance. Lifetime maintenance is also only granted in circumstances where the spouse who is claiming maintenance is not in a financial position to support themselves. So, for example, if a spouse is awarded a large amount of money or assets in the divorce, for example, that spouse may receive a house that is fully paid up and has no expenses other than the usual maintenance expenses, plus they get a fully paid for car, plus they get all the household contents, and then they also get an investment or a retirement policy, and together those are worth 10 million rand. The chances of then getting lifetime maintenance are vastly reduced, dependent on what the assets are that spouse is going to or has obtained. It will also be dependent on what the means are of the spouse who is being ordered to pay. Now, you've got to bear in mind, I'm going to go back to the fact that a spouse at some point or an ex-spouse is going to stop working and potentially then go on retirement and not have an income like they had before and be reliant on a pension fund, possibly on a business, if they were lucky enough to own a business and have a successful business that they keep and it continues to pay them. But their circumstances may well change and they may not be able to continue to pay or be able to continue to pay to the extent that they were paying when the order was granted. So these sort of things are always considered by the court and have to be borne in mind when you are making a claim for lifetime maintenance. Now, the more common thing that is ordered in respect of spousal maintenance is a rehabilitative maintenance order. This is where the spouse that's claiming maintenance has earned an income, or perhaps prior to getting married was earning an income, left the job market in order to raise a family or support their spouse in their business or their work, and needs an opportunity to get themselves into a position where they can again earn an income that is sufficient to enable them to provide for their own needs. That's a rehabilitative maintenance order. And the length of time and the amount that is payable is completely dependent on the circumstances of the parties. Some spouses may get 5 years, some may get 6 months. It all depends on what their particular circumstances are. Now, when claiming for maintenance post the divorce, much like an interim order with regards to Rule 43, you have to be able to set out what your needs are, why you need what you need, and why you need the maintenance for the period of time that you need it. So if you need it for a lifetime, why? Or if you need it for a year or 5 years, why you need it for that amount of time, and then that your spouse is able to afford to pay those and that those needs are reasonable. So again, you're going to have very detailed information, and you need to bear in mind the amount that you receive and the period of time that you receive it for will also depend on what assets, patrimonial payment you receive as a result of the divorce. So I hope that helps you with a little bit of information with regards to maintenance for yourself as a spouse in the divorce proceedings and post the divorce.